Right, let's bring in immigration law expert Ashraf Essop to unpack the laws around immigration in South Africa following the spate of clampdowns on illegal immigrants in the country and more. A very good afternoon to you, Ashraf, and thank you for your time with us here on the SABC at this hour.
Hi, good afternoon, and thanks for the invitation.
I want to look at the changing political and economic dynamics in South Africa over the past 30 years, having changed considerably, and perhaps also looking at next year's elections since the minister unveiled his proposals, and really just gather your thoughts how migration has become a major campaign issue. What are your thoughts on the immigration laws in South Africa as we speak?
Well, as we speak, there is a government gazette that's advertising public inputs, specifically regarding changes to the Immigrations Act, the Citizenship Act, and the Refugees Act. And the Minister of Home Affairs has invited comment and participation until the 19th of January 2024. So this alone tells you that the matter of migration, visas, immigration is extremely important to the country. You'll also appreciate that we have had a recently published critical skills list that was upgraded about a year ago. And that critical skills list lists a number of skills that the Republic is in desperate need of. And foreigners in possession of such skills will be able to enter and work and reside on the critical skills list if they fulfill all of the requirements. With regard to, let's say, the other area of migration, we appreciate that there is the Refugees Act, which again was amended, and some of those amendments were recently challenged, such as the automatic loss of your refugee status if you failed to apply for same within 30 days. So as you can imagine, this is a very important part of existence, but immigration is not new. The Immigration Act of 1913 also speaks of undesirable foreigners, illegal persons, prohibited persons. So it's part of our country's history, as it is everywhere else in the world, that you will have migration. The question then is, which migration is welcome and which is not? So you would understand from the preamble to the amendments that the minister has published, he was suggesting that every country has a right to, as part of its sovereign responsibility, of course, to welcome immigrants or refuse persons entry. And I think everyone is at idem that any kind of migration has to be legal. Of course, the host state like South Africa also must benefit from the migration of foreigners. Now, South Africa's mining history was built on the backbone of foreigners who worked for many, many years in our mines. And these were all from the neighboring countries. And of course, we know during apartheid, people from Rhodesia, as it was then known, before it changed to Zimbabwe, were welcomed into South Africa without any kind of skill. So if you're talking about the political angle of migration and illegal foreigners, etc., it is an immensely important topic. But any topic that we discuss has to be measured against the Constitution. We have a constitutional democracy. This was something denied for our people for almost 340 years. Now, since 1994, we have a constitutional democracy, and the Constitution very clearly states that the Bill of Rights is the cornerstone of democracy. Now, one has to introspect into what are the rights in the Bill of Rights, and there are numerous rights. One of the rights that you enjoy is the right of freedom and the right to be presumed innocent until proven otherwise. The Immigrations Act itself makes provision, very importantly, for the deportation and detention of illegal foreigners. So when you have pieces of legislation that clearly spell out what the rights and entitlements of both the state as well as in this case, foreigner, then I submit that we have to pay very strict compliance with those acts. Otherwise, we will become another state that doesn't really obey the rule of law or is not concerned with rights and privileges. And it's very, very important that we pay attention to what I would suggest is a separation of powers as well. So if I could give an example, let's say you have a judge who faces every single day having to sentence people that are drunken drivers. Can you imagine if that judge suddenly goes on a campaign all of his own, standing outside the taverns and himself arresting people? You could see how that intrudes upon the separation of powers. So we have the Immigrations Department, we have the Police Department, we have the Army. The Army is not always deployed in civilian matters, but we now have the Border Management Authority. So no matter how one perceives their success or failures, we have to abide by the rule of law. And only an immigration officer and a police officer may arrest an illegal foreigner. And in terms of Section 34 of the Act, and irrespective of whether such foreigner is arrested, deport him or cause him to be deported. And in terms of certain discretions allowed to the immigration officer, pending his deportation, detain him or cause him to be detained. But here I must add a very important rule, which was made, a comment that was made by Judge Kachalia in the Ulde matter as far back as 1998, I think, where he said that you must always favor liberty. Now, arresting an illegal foreigner is not without recourse, because the Act says, in terms of Section 34, provided that the foreigner concerned shall be notified in writing of the decision to import or deport him, and of his rights to appeal such decision in terms of the Act. Now, the rights of appeal are contained in Section 8 of the Immigrations Act. It's very, very important that one has recourse to those provisions, because you have to be given a set of documents. You have to be given an explanation. There are certain events that trigger two kinds of appeals. One is where you have entered the Republic and you are found to be illegal, and you are notified of that in Form 1, which is a prescribed form. Yeah. And if you are able to, you must get your representation to the minister. You would also appreciate in terms of Section 34(2), where foreigners were held in excess of 48 hours, these were declared unconstitutional. So what I'm suggesting is there has to be provision for the rule of law, and we cannot resort to self-help.
Ashraf, thank you for those opening remarks and for those sentiments. I want to hone in a little bit because you've spoken about the changes to the Immigration Act, Citizens Act, the Refugee Act, and even that release of the critical skills list. And I wonder, given the policy trajectory and how it positions migrants, what your thoughts are on regarding that. But also if we're looking at some of the concerns about the risk-based security approach, what arises on that front, given the dangerous xenophobic narrative or rhetoric that might also be coming through? How do we manage that as well?
So there has to be always the rule of law and the Constitution that has to be put first. The Constitution appeals to every government, body, and individual to uphold the rights in the Constitution. So while we're not denying, and we cannot deny, the impact that foreigners have made on the economy, and I would suggest the pushback by government, because there's various pieces of legislation, not just the Critical Skills Act. There's the Employment Empowerment Act now, where every employer has to report to the department how many foreigners they've employed and in what position. The critical skills list was drawn up with various government organizations participating in it. It's not a finite list. It will evolve over time. So one has to manage the needs and security of the Republic, which is in the Immigrations Act itself. But it also says against xenophobia. One has to guard against xenophobia. So you could see that such a topic was very, very high on the agenda of the drafters of that piece of legislation. They knew that South Africa has a problem with xenophobia, and they have to guard against it. They have to make sure that the right kinds of people with the right kinds of skills are allowed in. But not only that, you'd appreciate that a lot of South Africans have married foreigners and have children and families with them. And again, when we speak of the Bill of Rights, it protects the right to dignity. And for example, a right to dignity encompasses a right to marriage and family, and the rights of children, which is protected in Section 28 of the Act. So one is to take all of these things into account in deciding how to deal with a particular case. It cannot be that we make general rules. It has to be on a case-by-case situation. Therefore, the person that is affected, as well as the state wanting to protect its security, has a fair chance in court. As you'd appreciate, a number of foreign military generals and things have been held in our courts, have been sentenced by our courts and held in prison for being a threat, a security threat, having committed crimes of genocide in other areas of the world, and they've been incarcerated in South Africa. So you could see that the right to security of the state is not negated by the rights extended to foreigners.
Ashraf, I need to wrap up. I just want to let you go by asking this closing question, talking to the difficulty of perhaps counting foreign nationals, especially those who are undocumented, the impact that it has had in South Africa and continues to have in South Africa on that front. And really, as we look at the immigration policy in a post-apartheid South Africa, what is it going to take from your vantage point as we wrap?
Well, there's absolutely zero reliable data. There was census recently, and it seems to indicate that we have anything between 300,000 and 15 million foreigners, documented and otherwise. So it's a massive problem that the legislature will have to deal with, as would the Department of Home Affairs, as would employers, and as the people themselves have to be honest enough to come and try and attempt to fix up their status. It's a massive task.